Hello, chat. Hi, guys. It is Tuesday night. I was about to say Wednesday. It's like, we're not there yet, but little Clyde ASMR to get the night off right. Hi, Bubba Bear. You're such a good boy. Welcome to the show. Welcome to the show, chat. Hi, Clyde. Yes. So, we got one more, Clyde. Can we get high tonight, buddy? There we go. Got a little dog ASMR going. All right. Oh, Luke's bringing up Lori Vallow's not going to be streamed. It's not going to be broadcast. Oh, that sucks. That's no fun at all. Who would want... Oh, he's tired. Eating all those weed treats get you tired, Bubba. Well, anyways. Welcome to the show, guys. Welcome to the show. Clyde has bangs. Yeah, he kind of does. That's what happened with Shih Tzus. That's how they look. Total Clyde victory. That's right, chat. Total Clyde victory, because he's a good boy. Total good boy victory. The good boys always win. Come here, buddy. Oh, look at him, chat. He's like, oh, he wants to hug. He wants a hug. Oh, come here, Bubba. Oh, yeah. Oh. Well, anyways, guys, welcome to the show. If you guys are new, my name's Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland area, and we are talking about Karen Read today. Karen Read's case came down from the Massachusetts Supreme Court, and I have not had a chance to read it. I've heard some things about it. Listened to, while I was coming home from court earlier today, I listened to Emily Baker, probably for like 10 minutes. So it's very interesting. It's a very interesting thing, and it says it's going to cover some things, and basically, you guys already probably know the TLDR. Karen Read got felted, completely blown out in this. The court backed up everything that happened at this point. I think I even said this before, kind of what we thought was going to happen, and we're going to talk about the issues that happened, and, a lot of it's, from what I understand, they cite the things I already said. One of the biggest things was when the, if you guys don't remember, Karen Read's on trial for the murder of John O'Keefe, and she's accused of running into him with the back of her car and basically mortally wounding him. And then he leaves, or depending on how you look at it, basically he's just knocked out and laying in the snow on a very, very cold night in a couple years ago, and he freezes to death, basically, coupled with his injuries. So this is the trial where they're like, she said, I hit him. They found his body in the snow. The police used like red Solo cups and other moronic means of evidence protection and production. We found out half the Massachusetts State Police is highly corrupt. All the detectives on this case have been disciplined and or fired or in the process of being disciplined right now. We know that this is the case also where all the witnesses involved miraculously dumped their phones before they were subpoenaed. It's always weird. Always kind of weird stuff like that, chat. Always kind of weird stuff. So there's a lot of issues here. This case went on for a while. She ended up with a hung jury, and it ended up being hung on all counts. As things went on in the aftermath of the hung jury verdict, the defense learned from jurors, like, actually, no, we were not guilty on count 1 and count 3. We had fully acquitted her, but we were not acquitted on count 2, so therefore we didn't stop. Well, that's not how the notes to the court were done, and that's not how things ended up panning out. So at that point, Karen Read and her team filed motions to have that issue addressed. More importantly, just the idea that if there was an acquittal, well, an acquittal's an acquittal, an acquittal is final. But that did not happen. None of that was sorted out. And obviously some of the jurors are saying that happened. Not all of them are saying it happened. A bunch of them did not talk. A bunch of them didn't get involved in the court process. So the court denied the motion. And Karen Read was still looking at trial. And since then, she appealed it up the chain. And that's where we are. So The ultimate issue is they're trying to argue that Judge Canoni did not poll the jurors properly and didn't do a lot of things that she should have done, but we're going to get into that now. And Clyde, I'm going to put you down because we're not putting him down, chat. We're not putting him down. But I gotta have to set him on the ground because I need to be able to use the mouse. What you think, Bubba Bear, huh? Huh? You want to say goodbye to everybody? What's that? Woof. Support Doge. Woof. Oh. Once you support Doge, chat. Once you support Elon and the Doge boys. Support big balls out there. All right. Well, Clyde, I'm going to have to put you down, Bubba. You want to say goodbye to everybody one more time? Huh? You want to say hello? All right. So I'm going to put him down, chat. Hold on, Clyde. I got you, Bubba. I got you. There you go. Good boy. Good boy. You're all set. Ugh. And remember, chat, if you ever are looking for wheat treats, these are phenomenal. Nature Vet Hemp. They do great, and they are on Twitter. They also have like an allergy-based kind, which are pretty cool. Pretty cool. You guys missed Clyde already? Well, suffer, chat. Suffer, chat. Oh. Why do all the attorneys on YouTube present present company excluded, neglect permissive language? What do you mean, Alpha? Where do they neglect it? Where do they neglect it? Because I don't pay attention to it. So anyways, we are moving on here though, chat. We are going to move on. So it came out today, and yes, it's suffer. It's suffer time, chat. Oh, come on. Where is... Oh, hold on, chat. Hold on here. Why can't I? There we go. I'm trying to get rid of some things here. Oh, looks like Patrick Tomlinson is going to trial, which is like very weird, but it looks like that's going to happen. So here we go, chat. This is the motion. There have been some updates in the Trump stuff. Basically, First Circuit told Trump to kick rocks. So we're going to see our constitutional crisis unfold tomorrow because we have no ASAP Rocky trial. So we have time all night to prepare for that. So we will get to that. But this is the Commonwealth. Karen Reed versus the Commonwealth. So here we go. Here we go, chat. Oh, it's time. And yes, Aaron Hack's been a member for 18 months. Thanks you for being here, Aaron. Nice support. Says bring on Mark Bedrow. Yes, Mark has officially thrown his hat in the ring for the Karen Reed team. Everybody's coming to fight now. Everyone's coming to fight. So it will be very interesting for her. Very interesting for her. So here we go. Here we go, guys. So this is this stuff up here is just saying this is the slip opinion. And this is a slip opinion. It just popped out hot off the press today. So it's subject to revision and other things. That's why you don't see a case citation. Just like when you see a Supreme Court case and you'll see like blank lines, there's no official citation yet for this. So that is how this works here. So anyways, this is Karen Reed versus the Commonwealth. All right. And they talk about all the judges that were present, you know, the Chief Justice, Chief Judge, and all the other judges there. And now they talk about different things here. There's different topics here. The superintendents of inferior courts. Now, what does that mean as far as superintendents goes? Like the governing and leadership of an inferior court. Now, you have that in every state. Like here in Ohio, we have rules of superintendents where the Supreme Court has said, here's how shit runs. Here are some major critical rules that have to be addressed. It talks about homicide, motor vehicles, homicide. These are all kind of like the subjects you could search for. And then if it's underlined, that means it's actually kind of big. Kind of an important thing here. So they talk about all the parties involved. You know, you can see David Yannetti was here. Alan Jackson was here. All the parties that were involved in this. You also saw the ACLU submitted an amicus brief. What'd you just do? You're okay, buddy. So it says the defendant challenges their motion to dismiss after a first trial ended in a mistrial. The trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses, 657 exhibits. That's a lot, chat. The defendant does not contend this evidence was legally insufficient to support a conviction on any of the charges, which would preclude a retrial. And that's an interesting thing. They're not saying the evidence was legally insufficient. Remember, that's something you normally will challenge and say there's a sufficiency of the evidence argument. Now, they're not precluded from doing it the second time around, but, you always make an argument that there's manifest weight, there's insufficiency of the evidence. Those are typical things you always argue on an appeal. They say instead, our argument focuses on whether the trial judge properly declared a mistrial and the relevance, is any, of post-trial accounts of jury deliberations. Now, they bring up the point the jury deliberated for 5 days, sending progressively insistent notes to the judge about their inability to reach a unanimous verdict. You guys remember, they were very much on the, we can't sort this out, Judge, we need help. And Judge Cannoni was kind of a tart about it. Now, from here, chat, we do have, they say in their third and final note, the jury said that some members firmly believed the evidence had passed the burden of proof establishing the elements of the charges, while others did not. They described their views as rooted in sincere adherence to their individual principles and moral convictions, and stated that further deliberation would be futile and forced them also, real quick, guys, they point out here, the record submitted to the single justice and now before this court does not contain transcripts of the testimony or the exhibits from the defendant's first trial. And that's because they're not talking about that. This is all the post-trial motion practice and the hearings we saw, because we covered those things. This is all focused on post-trial and really the back end of everything. And they say, based on this final note, the judge declared a mistrial. The defendant's motion to dismiss and this petition rely on post-trial accounts from several jurors. Notice not all of them, but several of them. These accounts suggested during deliberations, the jury unanimously agreed the defendant was not guilty on 2 of the 3 charges and were deadlocked only on the remaining charge. And like I said, chat, from what we understand, they were deadlocked on count 2, but they had agreed count 1 not guilty and count 3 not guilty, just leaving count 2 as the only one open. The defendant argues that a mistrial was thus not manifestly necessary because the judge could have requested a partial verdict from the jury before discharging them. I will tell you, I don't recall that being the issue at the time. And when you're a defense attorney, you normally don't want to force a jury to come to a compromise because it's not going to go your way, is generally the major fear. And that would be my fear if I was in this situation. Like, oh my God, I don't really want to risk like us getting burned on this. So why would I want to go in there and say, hey, judge, make these sons of bitches do it? It's like, no, that's very, very, very risky, guys. It's very risky. I would never want to do it. I would never, ever, 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 ever want to do that. That would just, because, the idea is, yes, if you knew that you were holding the high ground, it's great. But the jury's deadlocked. Is it 10-2 in your favor, or is it 10-2 in their favor? Do you really want to try to force things to happen? You don't know. You don't know, chat. And that's a little bit of this is a very unique argument that is being alleged here that we should have kept going. Because normally, chat, we've talked about this before. We've seen it before. When you're in the middle of trial and you're dealing with this, what do? You say, no, Your Honor, we're going to the jury can't come up with a verdict. We're going to take the hung jury and go home. And that's because normally that's it. The state doesn't retry. It's a little different here. The defendant further asserts the post-trial accounts show she was in effect acquitted of 2 charges, and that double jeopardy bars retrials on those counts. Yes, if she was properly acquitted, that would bar a retrial under double jeopardy. So the question is thus raised. Can the post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in open court? And they say, we conclude that they cannot. So like I said, chat, we're on page 3. Spoiler alert. Spoiler alert. And that makes sense because ultimately we may want this outcome, but you notice the big thing is here. The jury did not announce or record a verdict in open court. It's just like for those of you who are engineers or in the medical field, if it's not documented, it didn't happen. Oh, well, that's how we felt, but you didn't come out and fucking say anything. There's nothing on paper. None of you stood up in the middle of court saying, Your Honor, but we found her not guilty on the other counts. Everybody just sat there quiet as a church mouse. So there's nothing you can do. The record is silent, and the record is what the court relies on. The jury clearly stated during deliberations they had not reached a unanimous verdict on any of the charges and could not do so. And that's the court determining things here. It says, only after being discharged did some individual jurors communicate a different outcome, contradicting their prior notes. Such disclosures cannot retroactively alter the trial's outcome, either to acquit or convict. Accordingly, we affirm the trial judge's denial of the motion to dismiss and the defendant's request for a post-trial juror inquiry. So that is where we are, guys. It's just, it's what you got to work with. It's what you got to work with here. And they don't have the strongest arguments here. So they talk about the trial and deliberations, okay? Well, we're going to skip this part here about the whole thing going on. And they say, they go over it. So the trial was over 2 months. On the 37th day, the jury received instructions regarding the 3 indictments and the 2 lesser included offenses for count 2. Involuntary manslaughter and motor vehicle homicide. And chat, from what we understand, count 2 is where they were stuck. Count 2 is where they were stuck. Before the deliberations began, the judge indicated that the foreperson would be given separate verdict slips for each of the 3 indictments. The judge then explained the procedure for delivering the verdict. And she said, after the final vote, the foreperson should check the appropriate boxes of each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. So the judge then also instructed the jury to continue deliberating until you've reached a final verdict, and to not disclose their standing or progress to anyone. And it says, before such time as you reach a unanimous verdict. So the jury began. And then 3 days later, after 19 hours, which is a lot, that's actually a lot of time of them working. He says, I'm ready to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration, we have been unable to reach a unanimous verdict. And that happens. After reading the note on the record, the judge requested argument from the parties on whether the jury had conducted a due and thorough deliberation, warning a so-called Tui Rodriguez charge. And that's what they call it there. They call it an Allen charge in many other places. But that's the case that they call it here. Says the Commonwealth argued the jury had not deliberated long enough, while the defense disagreed, requesting the instruction and asserting the foreperson's use of the word exhausted suggested an impasse. The trial judge determined that further deliberation was appropriate and instructed the jury to continue. The deliberations continued throughout the afternoon and resumed the following Monday morning. At 10:45 a.m., the jury sent another note saying, and this is where they get to the point of saying, despite our commitment to the duty entrusted to us, we find ourselves divided deeply on our opinions and state of mind. The divergence in our views is not rooted in a lack of understanding, but deeply held convictions that each of us carry, ultimately to a point where the consensus is unattainable. And they say, we recognize the weight of this admission and the implications it holds. Because they're realizing, look, if we don't get it right, they're going to have another trial. Say, upon receiving this note, the judge again invited argument. The Commonwealth acknowledged the jury had already deliberated nearly a day total at that point, but argued it was premature. Defense counsel maintained the jury were hopelessly deadlocked and again requested the Tui Rodriguez instruction. Once again, the Allen charge to, go back in. The judge agreed with defense counsel, knowing the jury had been extraordinary and she had never seen a note like this. And the court says, it appears the jury had deliberated closer to 24 or 25 hours by this point. It's a long time to sit there and do this. The judge then delivered the Tui Rodriguez instruction on the jury and sent them back. And at 2:30 p.m., they came back with their final note. They say we've continued to find ourselves at an impasse. We're starkly divided. And believe the evidence. Some people do believe that established the evidence beyond a reasonable doubt. Conversely, others find that it fails to meet that. And they say this division is not due to a lack of diligence, but rather a sincere adherence to our individual principles. And he says to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Yep. That does happen here. Kurt, hey, how you doing, man? Kurt from Uncivil Law, guys, friend of the show. Hope you're doing well, Kurt. Hope things are going well. I know you've been hitting it hard out there covering the EOs and all the stuff that's been going on with Trump. So, guys, during the day, if you guys want to see some of that stuff going down, Kurt has been giving live coverage of it. Kurt has been giving it live coverage. So give him a look. Uncivil Law, your place to go for all that right now. Let's see here. So after the third note, judge informed counsel the jury's at an impasse. The jury were called back in the room. The third note was read aloud into the record. Upon reaching the final line stating the further deliberations would force the jury to withhold those beliefs, she says, I am not going to do that to you folks, and declared a mistrial. I remember we covered that when it happened. The judge then discharged the jury back to the deliberation room, explaining she would meet there privately and thank them for their service. And guys, if you remember how that hearing at the end went, it was like boom, 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 and they were done. Like, it was over like in a flash. Like it was a nice, like it was I think it was like getting towards the end of the week, or it was a Monday, but it was like a really nice day outside. It was June or July, and everybody's like, we're getting the fuck out of here. And everybody just went right out the door. Karen Reed and the defense team they were like, feet don't fail me now. And Fred Flintstone their way out of there. I don't blame them for that. Okay. Because really, guys, if you're in a trial and you're here in deadlock, a hung jury is a win. And I've said this before. When you and your client walk out the front doors of the courthouse, anytime you get to do that is a good day. Karen Reed walked out the door as she walked in. That's a good day. It's not the best day ever, but it's a pretty goddamn good day. Okay? You ain't eating some really good A5 Wagyu, but you're having a pretty good, you're having like a Black Angus quality steak. You're having a really good steak. It's not the Wagyu, but it's close. It's good. It's good. You're having a good day. And that's what it is. So that's where you have to start. But remember, as soon as she declared a mistrial, everybody was just right out the door. I mean, we saw that. Everybody, Karen Reed, they escorted her attorneys, got her the hell out of Dodge. So that was not a thing. Now, what happens from here? And they talk about it. The judge discharged the jury back to the deliberation room, explaining she would meet with them. The judge and the parties remained in the court to discuss their availability to schedule a status conference on the matter. And it's something I brought up back when it happened. At no point during this discussion did defense counsel object to the judge's declaration of a mistrial or express disagreement with that outcome. Remember, chat, if you don't say anything, if you don't object, it's deemed waived. Remember, you have to protect your record. Now, I understand, and here's the thing, I will say Yannetti and Jackson did not commit malpractice. So I heard some people saying that on Twitter, things like that. They thought they fucked it up. They didn't fuck up. They didn't fuck up. But did they neglect to do something? Sure. But at the end of the day, this is it's interesting. It's interesting in that regard. But you have to protect your record. You have to protect the record. But I get it. That moment, you're like, we just won. We got them by the balls. We're gonna move hard and fast here. You know, you got what you needed. Trial's over. But nobody said anything. And I've said that before, and I think I even said it like right at the time, like nobody's objecting anything. They seem to be cool with it. And then as we had other dates and other motions going along, they did not do it. It's Trenton says the judge didn't let him get a word in edgewise. It doesn't matter. If you're to the point where the judge is not letting you get your word in edgewise, you stand there and you refuse to leave. And you say, Your Honor, I would like to be addressed before you stop the record. Your Honor, I need to make statements on the record. Just like we saw in the George Kelly trial out in Arizona. The judge can walk off the bench and you can still make a record. You can still make a proffer after the judge is gone. I've had to do it before after hearings. You don't fucking it's like a general order if you're in the Marines. You will never abandon your post. You will not leave your post unless properly relieved. You don't leave until you're basically forced out. They could have stayed. They could have made something on the record. She bulldozed them. Your Honor, no, I need to talk. No. Like, that's where you might have to act like a little kid and like, no, Your Honor, you can't do this. We need to make this on the record. We need to do this. And I'll say the George Kelly trial is a great example of that. People said, no, Judge, we need to make a record right now. Sometimes you have to do that. And, you know, that said, though, Jackson, you were like, fuck, we got the win. We're getting out of here. We got out of here. So it does make sense why they didn't do what they did there. They said, I'm not going to bag on them. I am not going to bag on them for that. And then real quick here, chat. We got Analytical T gifting 5 subs. That's right, chat. 5. Greenifying this chat again. Gentrifying it. That's right, Grays. We're moving you out. We're gentrifying chat. We are going to pray the gray away. We're bringing in the green visas. It's like OCP moving into old Detroit. You got nowhere to run. You got nowhere to go. Just accept it. So thank you, Analytical T, for stepping up like that and making it happen. Thank you. And then That's a Shame for $9.99 says, hot take. This is why I always feel more sick to my stomach after trial than before. You ain't... Let me just say, you ain't kidding, sister. Guys, yeah, there's times where you get done with the case, like, even if you lose, you're just completely blown out of the water. You're still like, oh my God, what did I get right? What did I miss? Did I miss anything? But even when you have a good outcome, you're like, you get very nervous. And I'm not joking, and the other people here who are attorneys will tell you, chat, it's a massive adrenaline dump, and like the stress and the anxiety just coming off of you. I mean, like when you go to trial and it's done, like I just want to go to you just want to go take a nap. Like it's that bad. It's just everything peels off of you. Because remember, when you're at trial, I've said this before, you are like wired all the time thinking about everything. You guys have heard me during the ASAP Rocky trial. I'm thinking about a million different things that are going on in this, and I don't even know their full evidence. So guys like Takapina and Lewin, those guys are like, just burning their brains out on this. It's real stuff. It's real things. So yeah, it totally is. But yeah, thank you. That's a shame. I appreciate it. So after trial, I just want to hit a Jimmy John's. Well, thanks, chat. Analytical T says, what happened to the 25K mark? I don't know. It just like YouTube is like, does every once in a while, it'll call off subs, I guess, saying like, oh, they're bots or something. I don't know. Where people are just fucking with it. I don't know. Maybe that's my goal, is to suffer. Is just sit here and suffer at 25K for now. I don't know. And I'm fine with that. I am fine with that. It's how the world goes. It's how the world goes, chat. You just got to keep grinding, keep doing your work. It's all you can do. So, and they go to the post-trial events here, and it says, according to the affidavits, a member of the jury, Juror A, contacted the defense after noticing the inaccurate reports about the jury's alleged split that caused a mistrial the day before. Juror A stated the jury unanimously agreed the defendant was not guilty of count 1, murder in the second degree, and count 3, leaving the scene of a personal injury resulting in death. 2 days after the mistrial, defense counsel also received screenshots of text messages with jurors or their acquaintances describing the deliberations. Another juror, Juror B, said it was not guilty in the second degree and split in half for the second charge. In another exchange, an individual referred to as informant by defense counsel was advised another juror, juror number C, had told friends there was no consideration of murder in the second degree, and the jury deadlocked on the remaining charges. So see, here's the bigger issue. So even though, let's say there were like a bunch of these jurors came forward, they're still not even agreeing amongst themselves about what things they're actually agreeing to. Some of them are saying, like, we're agreeing to this much, but this juror is like, I only agree to part 1. This juror is saying, maybe I agree to part 1 and part 3. But you have a problem here where these jurors are not having the exact same story. So that causes an issue about what are we looking at and what actually happened there. So it also said the manslaughter started pulling at 6-6, then had a deadlock with 4 no, 8 yes. So see, guys, that's why you have to be careful, because look, it started 6-6, and then it turned and not in their favor. Juror C had also reportedly stated the jurors had a group text going. I don't know if that's all good, but anyway. If they all agreed on no for murder too, they should make it clear to the DA and the court. It's basically a case of double jeopardy if she's retried on that charge. So they talk about July 8th, 1 week after the mistrial, the defendant filed a motion to dismiss based on the accounts. The defendant argued the accounts showed the jury had effectively acquitted her. Notice it says had effectively. Well, it didn't properly acquit her of count 1 and count 3. And remember, and that's not even clear, because not everybody's saying count 1 and count 3. Some are saying one or the other. Some are saying both. She further contends the mistrial was improper for these 2 counts and requested at a minimum a post-verdict inquiry to confirm whether the jury had agreed she was not guilty. So they also found other people, Juror E. They also found Juror D that went on there. And they said that, it was only about count 2. Well, we don't, it's not clear. Juror D claimed that after discussing the matter, the jury ultimately decided to inform the court they were deadlocked, and they expected they would get further instruction about the remaining counts thereafter. So they assumed, but it didn't work out that way. What are you guys saying here? All right. Well, anyways, so the Commonwealth also submitted a post-trial filing notifying the court that after the submission of defense counsel's affidavits, it had received 2 voicemails from a member of the jury. So remember, this is not the jury unanimously saying, hey, we had an agreement. Some of them are saying no. The jurors specified the jury had voted not guilty on counts 1 and 3. That was the last vote, 9-3 guilty on the lower level manslaughter charges. The Commonwealth also received email from 3 individuals who identify themselves as jurors and asked to speak anonymously. Once the Commonwealth informed them that they may be required to disclose the substance of their communications to defense counsel or the court, however, the jurors declined to comment further. Then they say the trial judge denied defendant's motion to dismiss after a non-evidentiary hearing. And remember, they had a hearing, but there was no evidence taken. They were just making oral arguments. The judge reasoned because there was no open and public verdict affirmed in the court. Because of that, the defendant was not acquitted of any of the charges. And then a post-trial voir dire of jurors would involve an impermissible inquiry into the substance of deliberations. that's true, Chet. You're not allowed to pry into what was talked about in the jury room. That stays sacrosanct. You're not allowed to do that. You're not allowed to talk about juror deliberations and juror discussions. It's just not allowed. It's just not allowed. So, and I'm on the wrong case. There we go. They say, additionally, a judge rejected the defendant's argument declaring a mistrial was improper. She noted the defense had twice requested the Tui Rodriguez instruction, the final step before the mistrial, and raised no objections nor made any request to be heard when the mistrial was declared. And the judge remarked defense counsel were no shrinking violets during the trial, making it unlikely that when counsel heard the jury was at an impasse, that counsel would sit silently if they did not consent to a mistrial. So she's trying to say, like, it's documented these guys were not going to back down. Like, these guys are gunslingers, and they would stand up and say what and do what they had to do. She also concluded the mistrial was manifestly necessary given the jury's repeated statements of deadlock. So on September 11th, the defendant filed a petition for relief in the county court. Now, this is the interesting thing here. Although the defendant is ordinarily not entitled to interlocutory review of the denial of a motion to dismiss, we have recognized a narrow exception to this general rule in the context of double jeopardy claims. The Commonwealth does not contest that the review is appropriate in the circumstances of the instant case. And the instant case means the case before it, the case we're talking about, the case at hand. And that's important. Like, it's a double jeopardy issue. The idea of, are we going to have a trial or not? This is a pretty big fucking deal. We need to know. We need to know what's going to happen. We need to. So anyways, they filed this in the county court, and they say a single justice of this court reversed and reported the matter without decision to the full court. So it got all the way up. This was reserved and reported. So the defendant's retrial was scheduled to begin on January 27th. The retrial has since been continued to April 2025. So it's going to start April 1st, guys. I have a big issue. Like, I've had a couple times before where I've had trials or something. I've had a trial schedule start on April Fool's Day. I've always asked to move it. Like, when we're scheduling stuff out, I'm like, can we not do it that day? And the court looks at me and it's like, why? And I'm like, I just feel like you're tempting fate by having a serious matter tried when it's a day of joking and buffoonery. So I always refrain from doing it that day. I would never want to do it. I would never want to do it. So the propriety of declaring the mistrial, was it proper? So they talk about the double jeopardy clause of Fifth Amendment that precludes you from being tried more than once for the same offense. Yes. The exception is when a mistrial is declared due to manifest necessity. In such instances, double jeopardy does not bar the state from retrying you. Okay, chat, and a hung jury is a great example because there is no verdict. A hung jury is no verdict. We couldn't reach one. And they say determining whether the declaration of mistrial is necessary, a trial judge balances the defendant's valued right to have his or her trial completed by a particular tribunal against the interest of the public in fair trials designed to end in just judgments. And they say a hung jury has been long recognized as a traditional example of manifest necessity, allowing retrial without offending double jeopardy rights. And this is Richardson v. United States. It's the Supreme Court where they say jeopardy does not terminate when the jury is discharged because it's unable to agree. And they say the decision to declare a mistrial is entrusted in the sound discretion of a trial judge. And that's true everywhere. That it's all within the trial court's discretion. So they're allowed to do that. And it's their call. And trial courts receive such discretion to avoid the possibility of coercive measures being used to force jury agreement. And they say that it's done to prevent that or prevent the appearance of it. So they say in evaluating whether the trial court abused their discretion, a reviewing court considers whether the judge carefully explored alternatives to a mistrial and whether counsel were given full opportunity to be heard. They say if these principles were followed, there is no claim of insufficient. If these principles were followed and there is no claim to support an insufficient evidence to support a conviction, double jeopardy will not prevent the defendant's retrial, although there are times it can. And they said, because you have not argued about the legally insufficient evidence, we will not address the issue. That's another thing. If you don't bring it up, if you haven't argued it, they won't discuss it. So they say here, we discern no abuse of discretion in the trial judge's decision to determine the jury was at an impasse. After extensive multi-day deliberations, the jury submitted increasingly emphatic notes about their inability. And by the time the jury sent their first note, they had deliberated for approximately 19 hours over 4 days, which that's a long time. That's a chat. I think I've mentioned it before. Like, I've had trials where, like, misdemeanor trials where some people sat there all day long and then they realized, oh, we need to send out a note. So, after saying, would it be overreaching for the court to address something not argued? Yes. Yes, there are times where courts can act sua sponte, but generally on an appeal, no, they shouldn't be. If they didn't raise it, they should be deemed they didn't raise it for whatever reason they didn't raise it. Whether or not they forgot it or maybe they don't think it's a problem. But it's not the job of the court to guess that, oh, they must have meant this. So they point out the note had stated they give an exhaustive review and they'd done diligent consideration of all disputed evidence. And they said, following the instruction to continue their deliberations, the jury deliberated for another 5-6 hours spanning Friday afternoon and the following Monday morning. And that's before sending a second note that was noticeably more definitive. The note stated the jurors were deeply divided by fundamental differences. And they stop right there because there's some other stuff that isn't relevant to the discussion here. And they say that consensus was unobtainable. Sometimes it is. And it says, echoing language from other cases where you have characterized the jury's report of deadlock as unambiguous. And they said, this shows that, juror notes stating their hopefully deadlock was unambiguous to their inability to agree. Now, it'd be funny if this was Fuentes versus the Commonwealth. That would be hilarious, chat. That would be hilarious as a case. They said the final note stating that jurors were unable to come to a unanimous decision unequivocally reflected that they were deadlocked. Yeah, I mean, like, it's pretty obvious. The second note further emphasized the deadlock arose from a lack of understanding or effort, but from deeply held convictions that each juror had. And they say by this point, they had already deliberated for nearly 24 hours. That's just a lot of time. That's a lot of time, chat. But the trial judge did not immediately conclude that all hope of obtaining a verdict was lost. Instead, she issued the Tui Rodriguez charge, a standard instruction that encourages deadlocked jurors to reach a verdict by giving more serious consideration to opposing points of view. Like I said, chat, that's the Allen charge. So, then they say after nearly 4 hours of deliberation, bringing a total to 28 hours, guys. That's a lot. That is a lot of discussion, chat. That's a lot of deliberation. I mean, think about it in the cases we've watched. That is a lot of time. That's a lot of time. Justice Smith says, call it a Hawk Tui charge. Oh, no. So they say further deliberations would only be futile. It only serve to force us to comprise our deeply held beliefs. And they said there is no mechanical formula for determining whether a jury is deadlocked. They point out that a trial judge is acting within their discretion and concluding the jury were in an impasse and a mistrial was manifestly necessary. Well, I mean, this is where you're going to see. And the defense contends, and this is Karen Reed, despite the deadlock, the trial judge failed to adequately consider alternatives to declaring a mistrial. They say, yet as discussed, the trial judge did consider and pursue such alternatives. When they say after the first note, the judge instructed the jurors to continue. After the second note, the judge issued the 2E charge. And they said it's only when the jury submitted their third report of deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without their consent. Now, what does that mean without their consent, chat? So yes, the first couple of times she could force him to go back and force him to go back and force him to go back. It's when you put out this 2E charge, this Allen charge, you now can't, the judge can't keep sending him back. You're kind of forcing problems to arise. So let me see here. Now they say, nonetheless, the defendant argues the judge should have inquired whether the jury had reached an agreement on any of the charges. Had the judge done so, the defendant sure she would have discovered the jury had agreed on counts 1 and 3, allowing for a partial verdict. And they say, no, we don't buy it. We don't buy it. Now, what do they start with? They talk about Rule 27B of the criminal procedure. And this gives the trial judge discretion to require a jury to return a verdict for charges on which they have unanimously agreed before declaring a mistrial. The judge may first require and it says here, the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct such verdicts be received and recorded. It also permits a judge to poll the jury when a verdict is returned and before the verdict is recorded. They say, however, a judge is not required to accept a partial verdict before declaring a mistrial. So that's interesting here. This is saying the judge could accept a partial verdict before declaring a mistrial. So the judge could do things, but the judge doesn't have to. Notice she's being told she can do some things, but she doesn't have to do everything, which I think is an interesting thing that they're saying there. She doesn't have to do it before declaring the mistrial. Chat. There we go. So they point out that, and they're prohibited from doing so on a single indictment that contains lesser included offenses. And they said here the jury was instructed on 3 separate indictments along with 2 lesser included on count 2. But the trial record offers no indication that a partial verdict was imminent or possible. And I mean, that's the thing. Like, there's nothing to show that stuff was imminent. They were not, they weren't getting good vibrations out of stuff. And they say the first note simply stated they couldn't reach a unanimous verdict without reference to any specific thing. The second one reiterated that consensus was unattainable and acknowledged the implications of quitting. Neither note had suggested or reached the consensus of any subset of the charges, and we have cautioned against assuming a final verdict exists from general reports of deadlock. And that's the thing. Remember, you don't know what they're like when they say they're deadlocked. That's sometimes all they're going to say. And you also end up with like people wearing and acting in a way trying to disguise what they've done. Sometimes they're embarrassed of the verdict they've rendered. Sometimes, like, let's say they were letting out Hannibal Lecter, who was on a jury. You wouldn't want to be known as one of the jurors who let him walk free and go chop up and eat people, but, you got to do it. But we don't just let vague reports of deadlock allow us to pry into what's going on. That's not enough. So, and they point out that the jury notes and the judge notices, the jury notes provide no inkling of agreement on any of the charges. And they say, additionally, the notes did not request on whether a partial verdict could be returned. And the evidence is significant given the event and care that went into writing the notes and how articulately they expressed the jurors' disagreements. Send the Grays to Cleveland? No. They'll throw you in the lake. You will not survive here. This is the land of wolves now. Stephen Cooper, real quick. How you doing, man? Saying shout out to the IRS. I should have had my refund tomorrow, but Colorado isn't open for filing. Yes. Well, that's interesting. And I finally got the IRS to pay up to me that they had owed me, and I got their little interest thing in the mail, and it's like, hey, Sean, that money we were holding on to for you that you kept asking for and we wouldn't give it back? Well, now you owe us $180 in interest on it. And I'm like, what the fuck? Just, makes you love the feds that much more. Makes you just want to gas up a Ryder truck. Just saying. Just saying. Like, it makes you want to do it. Makes you want to do it so bad. So. And they say, in fact, the jury's third note implied they were deadlocked on all charges. And it says they emphasize that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. It says, conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. So, yeah, I mean, like, that's clear. That's not clear. That's not clear at all. It's not clear. And they say, although the defendant relies on post-trial affidavits, we assess the judge's decision based on what was known at the time of her decision. And that's true because that's the only way it works. If you can second guess decisions too far down the road, well, then there's no point in making the fucking decision anyway. And they're saying allowing post-trial juror accounts to affect the analysis would create endless confusion and controversy. Because here's the thing, chat, the jurors could be lying. They could be lying. They could be stuck on one side or another, and they could be trying to manipulate and cause problems. You just don't know. You just don't know. So, but it would cause endless confusion in cases where a mistrial has already been declared due to deadlock. And they cite a case out of the Sixth Circuit up here in Ohio. And they say, in short, the record before the trial court suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. And I think that's fair. If they haven't agreed on something, well, it looks like they haven't agreed. So, let's see here. Where are we at here? So, and they talk about the theoretical availability of partial verdicts does not obligate the trial judge to conduct further inquiry where no party has requested a partial verdict be taken, or the jury does not indicate it has reached one. So they're noticing like it's very limited because this note was written the way it was. This is from the guy who was the foreman. So if you've never seen him, like this is what they said. This is exactly what they said here. And they said emphasis added, so that means they're the ones who underlined it, not them. It says, further still, these notes indicated that an additional inquiry risks producing a coerced verdict. That's a problem here, chat. They have a concern here, and it's not good. And they say the judge must avoid actions that might pressure jurors into compromising their genuine views of the evidence. I mean, guys, how often have we seen that where like they'll give them, they tell them to go back and, oh yeah, here's that lesser included offense. And oh yeah, it's, what they're going to allow there is just, they don't want judges getting involved in that. And they said that deadlocked juries are particularly susceptible to coercion. Yes. As you guys saw with the movie, what was that name? On that movie. I can't remember at the top of my head, so I'll worry about it later. So, but yes, runaway jury. Runaway jury, John Cusack get it. Juries are eligible and susceptible to coercion, and I'm just like, hold on, is it runaway jury? Hold on, what movie is it? I'm trying to think. It's not Zootopia. Ernest Goes to Camp. No, it is Runaway Jury. It is Runaway Jury because it's got Gene Hackman in it. It's got Gene Hackman and John Cusack in it. Took me a second there, chat. We had to fire that up. Is that jury duty? Why would you say something like that? So runaway juries, yes, they try to influence against the gun company. Yes. The runaway jury is Alec Baldwin, right? No. Oh my gosh. Anyways, we're gonna keep going here. We're gonna keep going. Where did it go? Where did it go? Oh, right here. So they say it's precise for this reason, judges are prohibited from ordering further deliberations by a deadlock jury that is twice reported being in an impasse unless they explicitly consent or seek clarification on the law. I mean, that's the only time you can send them back is if they volunteer to go back. And there are limits to this, chat. I mentioned it before. We talked about different cases in common law where, like, there's a case where the judge tried to jail a jury because it wouldn't return a verdict that he wanted. Like, it was clearly a, that the court was seeking guilt, but they set the man free, and he jailed them because they weren't given the right verdict, and we had to have the high court in England get involved to say, well, their verdict is their verdict. You have to leave it alone. If they acquit him, he's acquitted. And they say the risk of coercion is also heightened when a judge inquires about the possibility of a partial verdict following a deadlock. And the concern there, and I know what they're saying, is you've already, like, you're introducing it. You're introducing the idea. And if you introduce the idea, they're going to take it and latch onto it because, remember, we're people pleasers. So we want to make the judge happy, but we also want to look like we're great and we're following the rules and everybody will clap for us. So yes, this idea of partial verdicts, if you don't tell them ahead of time, can lead to problems. But also, even if you do tell them, you end up with a lot of, basically, babies cut in half. So I don't want that. And they do say, though, what happens here, and they said when jurors have twice reported themselves deadlocked, and I've already heard the Tui Rodriguez charge, judges' inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. And they immediately, though, let the court know that, however, the inquiry is articulated or explained, the import of the inquiry is unmistakable. And this is the concern, is that the judge is basically saying, can't you at least decide a part of this case? They say the inquiry by its nature plays on the deadlocked juror's natural sense of frustration, disappointment, and failure. They said the jurors are confronted with the request and asked to absorb its inherent complexity. And they say at worst, possible time when they're tired, anxious to be discharged, and perhaps angry at the fellow jurors whom they blame for failing to reach the agreement. So this is a case that they're citing here. Some people call it a Kaiser blade. Well, we're going to keep moving here. It says, in this case, the risk of coercion were evident. Yes. And honestly, chat, like, nobody likes Judge Canoni and they think she's a horrible judge. Do you really want her dicking around with the jury? I know I don't. Like, it's just like, no, we're going to leaving well enough alone. Leaving well enough alone. And they say, far from suggesting that consent might be obtained, the third note made clear the further deliberation would only serve to force the jurors to compromise on their beliefs to their principles, locations, and their moral convictions. So they move along in here, and this is a bunch of citations here, but they say, asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial. Yeah, because they've already said, I can't come to an agreement. But now you're forcing them to come to another agreement. That's why the concern is the judge would be forcing them to just come to an agreement at that point. And you don't want that. You don't want to force people into these agreements. If they want to, do whatever they want to each other, fine. If they want to be in a relationship, they want to start a family, fine. But when you're talking about forcing this, if you want to go do it, great, but we're not going to force you to go into it. Because I've already said, I don't want to do it. Or I only want to do X, I want to do Y, and the judge is going to force him in. That means they'll do Z. But it's kind of like a relationship, too. We don't want to do it, and the judge is going to be like, no, arranged marriage. And you're like, I don't know if I like that. Sorry, Chad, it took me a second to come up with that, but I think that's kind of where I was going here. Sorry. Bifront says people hate love. Well, yes. But you don't want them, they're going to feel pressure that we need to unfuck this because remember, they're, it's part of the jury instructions. You're told, like, you're the best jury. We've put time and effort into this. It's not going to work otherwise. It's going to come down to you. That puts a lot of pressure on people. Alpha Fox says this is in India. Well, for now, you got to be careful. So they say in these circumstances, there is simply too great a risk that any resulting verdict would merely be a product of one hasty final attempt to satisfy the judge's apparent desire for some form of decision on the case. And that's a big issue here. That's what it's going to be. And they say if the judge were to inquire about the possibility of the verdict, by definition, any further discussion amongst the jurors regarding their response would itself be a further deliberation and in violation of the statute. So you couldn't ask it again anyway. Now, they said if the judge had inquired about a partial verdict on her own, and they're saying if that had happened, Judge Cannoni did it on her own, and then the jury returned a verdict of guilty on any count, there is no question this defendant would be making a strenuous and potentially meritorious argument that the guilty verdict was a product of a coercive intrusion into the jury process. So there are reasons why, if nobody had done this, and this had just been done by the judge, but Karen Reed hadn't asked for it, they're like, we probably would overturn that. But what's critical here, the defense is asking for it. The defendant's asking for all the stuff. It helps them figure out what they want to do. So they want it all, and they're saying, no, you can't have it. And once again, chat, we're just pointing out here, and the court's pointing this out, if this was any other situation, the defense attorneys would be losing their mind. They'd be pulling their hair out saying, you can't do this. They would say, you can't do this. And the court's saying, well, yeah, we might actually agree with you at that point. So that's what it leaves you with. So they said, given the entirety of the course of the jury deliberations and the emphatic language, the judge acted within her discretion in declaring a mistrial without inquiring sua sponte about a partial verdict. Now, remember, she can do it on her own. The courts, you have a lot of power, sua sponte, to do things. I mean, you were the judge. You have the ability to do a lot of stuff. And they already have prior case law where they say the judge isn't required to ask a jury if they would consent to further deliberations before declaring a mistrial because they'd already received the TUI instruction. So they say in final note, the final note unequivocally stated they were deadlocked. I mean, yeah. And it's to be fair, if this was, and Don't Bother None says they would find this harmless error, let's be real. We would say that, but I don't know if you can guarantee that's what would happen here, chat. I don't know if you can guarantee such a comment that, as much as I like to say harmless error, that would be a pretty serious error. That would be a very, very serious error on the case of the court to do that. So I don't think that would happen like that. I don't think that would happen. I don't. So I think there's a big issue. Well, it's not really a big issue, but I do you guys understand? And I'm sure you probably heard Peter Tragos, you probably heard Emily, you probably heard Bob and Allie talking about it. But I agree that yes, let's say the tables were turned. Yeah, Karen Reed and her attorneys be pulling their hair out of their heads over this. Now they say for the same reason, the trial judge's decision not to poll the jury sua sponte to confirm the deadlock did not constitute an abuse of discretion. And they say polling jurors about whether their instructions would be likely to result in deadlock is discouraged once again due to the risk of the coercion inherent in questioning the jurors, particularly in individual colloquies. Because it's one thing if the judge said, "Ladies and gentlemen, are you guys done? I read your note." Because here's how this would go. They're saying it's one thing if the judge is sitting there, "Okay, ladies and gentlemen of the jury, you say you can't read your note. How is that? You guys, is this true? Yes. Okay, we're done." Now, that's one thing. But to sit there and say, "Juror number 1, how do you feel? Is this true? Juror number 2, how do you feel? Juror number 3, juror number 4. Like, that is really fucking intimidating. And you would cause a lot of problems. So I can see why they're saying, and I don't know if I'd want that. Once again, if I'm the defense attorney, remember, we're getting a hung jury. It's like, why? Like, generally speaking, you kind of accept that. You kind of accept that. You'll take it. You will take it. They say the trial judge is not required to consider every conceivable alternative before declaring a mistrial. And that's true, because remember, guys, if this part here was true and this was a thing that happened, this one right here, this bit about the judge is not required to consider every alternative before a mistrial. Remember, if the shoe was on the other foot, and the defense is screaming, "Look, you've already done the Allen charge, the Toohey charge, it's time to go home. Hit the road, judge. Start the bus." And she's like, "No, there's more we could do." They would be screaming and flipping over tables and jumping up and down. No, you can't exhaustively go through every single alternative. What are the reasonable alternatives? Not every conceivable one. So once again, they're pointing out that had this been on the shoe been on the other foot, this would not have been something they would have been okay with. And they said, and we discern no discretion of abuse in the judge not pursuing alternatives suggested after the fact by defense counsel based on information obtained after the mistrial was declared. Yeah. And they say if an alternative was neither suggested by counsel nor considered by the judge as later developed, they will not fault the judge so long as an honest inquiry into alternatives is made. Well, yeah, if it's too late, it's too late. And they've said they've never required a trial court to consider any particular means of breaking the impasse. There's not a set standard because it's a case-by-case basis. What will work in case A will not work in case B. So that's why you have this issue about what you can and can't do. They say the defendant further contends separately from the availability of alternatives. It was an abuse of discretion to declare a mistrial without first notifying defense counsel of the content of the third note and allowing an opportunity to be heard. Now, they're saying first, it's worth noting that the trial judge has credited counsel's claim that he lacked such an opportunity. The judge explained that she had previously sought defense counsel's views after receiving each of the first two notes when counsel had argued the juries were at an impasse. The only alternatives proposed by defense counsel during these exchanges was the issuance of the Toohey charge, which the judge had granted. And they said when the third note prompted the mistrial, neither defense counsel neither objected nor expressed any dissatisfaction, even when the parties remained in the courtroom to schedule the subsequent status conference. Remember, That was on the record. The status conference setting the dates was on the record. And remember, everybody had cleared out and they were doing it. And notice they still weren't saying, Judge, we got to go back on the record. We have to address this. You got to let us do it. That didn't happen, chat. That did not happen. And once again, that's a clue that something wasn't there, okay? Also, hold on 1 second, chat. Oh, shit, where's that thing? Where is it? Hold on. Oh, there it is. There it is. There it is. So, Apex says, I didn't realize they found Karen Reed not. They didn't. I didn't realize they found her guilty. I stopped caring. Well, I can understand why that happened. I can understand that there. Yes, Tim, you're right. The defense would have came loudly if the impasse is broken with a guilty directed verdict. Well, there wouldn't be a directed verdict. You can't do a guilty directed verdict. You can only do a not guilty as a directed verdict. So they say even when the parties remain in the they said in any event, there's no indication that inviting defense counsel to participate in a third round of consultation would have provided any fruitful alternatives. And they say, as discussed, the receipt of the third note barred the judge from requiring further deliberation without the jury's consent. And it's just because they already engaged in doing thorough deliberations, twice reported being deadlocked. And they say nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury notes. Yeah, and there's nothing anywhere where they say, oh, yeah, we were going to look into this, or, Judge, we would have thought about that. No, you don't have any of that. So once again, you're kind of left with what's available. And you didn't bring any of this up, so it's going to be deemed waived. That's, that's what happens here. And they say this is actually a good case here, and they cite this. I love this parenthetical here. It says, having displayed no enthusiasm for the rendering of a partial verdict, while the jury was still impaneled and a guilty verdict still possible, the defense may not seek to overturn the court's order of mistrial after a discharge of the jury. And they say, while the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, which they should have done. They should have done. You read off the note to the parties and say, hey, counsel, here's what it is. Here's the note. You open it up. You read it on the record, say what either part. And, every judge I've ever been in front of, they sit there, they'll read the note, and then they go, hey, counsel, do you want to see it here? Do you want to read it? Do you want to take a look at this? Here, if you want to. Normally, I don't. There are times where I will want to see the note. But there's many times where you look at the prosecutor like, yeah, we're good. So what are we going to... And then we sit there and say, well, fuck, what are we going to do? What can we answer? How can we answer it? So they say, ultimately, in sum, we conclude the trial judge acted within her discretion in declaring a mistrial without first inquiring about a partial verdict or offering defense counsel an additional opportunity to be heard. And they say, considering the length of the jury deliberations, and that's critical, the length, the judge's prior efforts to encourage consensus, and the increasingly emphatic tone of the jury notes. And yeah, they're like, we got to help us. We're stuck. And they say indicating deadlock, it was clear the jury had reached an impasse. Yeah, well. Let's see here. So we're going to say further, nothing suggested the deadlock was limited to a specific charge. It says, on the contrary, the notes contain no inkling of agreement, and the third note implied they were deadlocked on all charges. Well, I don't think you could say they were deadlocked on all, but they clearly didn't specify that they weren't deadlocked on anything. So it's ambiguous. And I think there's more for them to say because it's not definitive. It's just ambiguous in its nature, and therefore we can't make a position one way or another. So that's all I would argue here. So, Pyrometer says, help us up. Stop, Judge. We're stuck. Oh, no, chat. Oh, no. And they say, under these circumstances, given the content of the notes and the fact defense counsel did not request further inquiry, engaging in one's sua sponte action, and once again, they're saying engaging in one's sua sponte action, they're saying the judge doing something of her own volition risked coercing a verdict. And they say, thus, the judge appropriately exercised her discretion declaring a mistrial based on manifest necessity. And they say that also, they go on to explain what happened here. And said the claims of acquittal. And they say the defendant separately argues she cannot be retried in count 1 or count 3, regardless of whether the mistrial was proper. She contends the post-trial information for 5 deliberating jurors. Remember, 5 of 12. That's not enough. That's not that many. Now, they do point out here, and they say for the purposes of adjudicating the motion to dismiss, the trial court judge accepted the purported juror statements as true and accurate. True and honest. True and honest jurors. For the purpose of this discussion, we similarly proceed from the assumption the affidavits are accurate. So they're going to say, we're going to spot you guys that everybody's telling the truth. Anyways, they talk about the 5 jurors who did reach out, saying the jury were deadlocked only on count 2 and had unanimously found her not guilty on counts 1 and 3. And they say that effectively amounts to an acquittal of those counts. And they say alternatively, the defendants, and this is Karen, asserts the trial judge abused her discretion in denying a post-trial inquiry to verify these accounts of juror deliberations. And they're going to examine these. So they're saying, did you do the juror deliberations? Did you do the post-trial interviews of everyone? Oh my God, you guys are ridiculous. So they say the claim of acquittal based on juror disclosures. When we talk about the Double Jeopardy clause of the U.S. Constitution, prohibits retrial for the same crime twice. So they go on to talk about it here. And notice they do bring up one thing here about the jurors. Juror C did not disclose information indicating whether the jury had unanimously agreed the defendant was not guilty on count 3. So you remember, as I said, chat, some of the jurors agree entirely, some partially, and some not really at all. So they determine whether an acquittal has occurred. We look to whether, given the operation of state law, the jury acted on their view, the prosecution, and failed to prove their case. And because it's a legal question, the review of the trial judge's decision is de novo, meaning they're going to review it from the beginning in its entirety. They are not going to abuse of discretion. They are doing this literally. They're going to strip it down, and they're going to take a look at it. They're just going to sit there and just tear it all apart and make sure it's good. Oh, geez. So they say, relevant here, the fundamental requirements for the jury is the issuance of a verdict in a criminal case are set forth in the Massachusetts criminal rules. And they say, pursuant to this rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. Remember, because we don't want secret verdicts. Case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. Yes, we want trials in public. So it's critical. It has to be done that way. It's open to the public, and it's given in open court, and it's affirmed and entered onto the record. It's critical. We have those things. They say, in other words, the distinction between an informal agreement on a verdict and the actual return, receipt, and recording of a verdict in open court is central. Only the latter constitutes a final verdict of the jury on a criminal charge. And it's important there, guys, because there actually is a process. Like, that's a formal way to describe an acquittal. But just saying, oh, we think they're not guilty, well, yeah, you're kind of not helping that. So they say we consistently reaffirm this longstanding distinction throughout our jurisprudence. So they say, in this case, it's undisputed. The jury did not announce a verdict on any charge. Although the defendant has submitted affidavits claiming it, the only statements made in open court reflected the inability to reach a unanimous verdict. Yes, very true. Very, very, very true. As discussed, the jury submitted 3 separate notes to the judge indicating deadlock, and they culminated in a final note indicating some members firmly believe the evidence surpassed the burden of proof. And that would be a great point to show that, hey, if some people think it was good enough, then they're not voting not guilty. They're voting guilty. Let's just say. And they say, far from an affirmation in open court, what is this? Far from an affirmation in open court of unanimous agreement on count 1 and 3. Hold on, chat. Oh, good. I'm going to have to... We'll take care of that. So it's far from... And they say that... sorry, guys. These notes clearly reflected a lack of consensus on the charges. Yeah. I mean, to be fair, that's a fair statement. Having actually seen the text of that note, yeah, it's very clear. We never got to see it before. That note is very ambiguous about what the fuck the jury was thinking. It's not clear. It's not clear. So, even if the jury's deadlock pertains specifically to count 2, their notes made no such distinction, nor did they indicate any verdict would be returned to the judge in open court as required by the criminal rules. And they say, in the absence of a verdict return, received, and recorded in open court, we cannot conclude the jury acted on their view. The prosecution had failed to prove its case. Now, that doesn't mean that these instructions were not clear or there weren't problems with the verdict forms and all that. It's just saying, look, the only way you have a verdict is if it's done in open court, everybody sees it, and everybody's there to scrutinize it. You can't just do a back of the napkin verdict. Can't do a verdict on a handshake. We don't want that shit. We don't want that here in our government. We don't want that in our life. So that's how that goes. That's how that goes. And they say that the defendants nonetheless argue that any lack of informality in the jurors' intended dispositions should not prevent those dispositions from taking legal effect. Now, the funny thing is, let's say we turned the tables and said, oh, these people said that it's going to be a guilty verdict, but it's not going to be on the record and we're not doing it the right way. Well, you wouldn't let that happen. You'd be like, no, we're not doing that. So, once again, I'm sure that they're going to get to this point here, but I don't recall if they talked about it. And they say that a verdict returned and affirmed in open court is far from mere formality. It says, these principles recognize that jurors may agree in the course of deliberations to a tentative compromise in the facts of a case or on disposition of related facts as they attempt to reach unanimous agreement. And they say, since a jury should not be precluded from considering a previous vote on any issue, and that's true, a tentative or conditional agreement reached amid deliberations cannot have the force of a final verdict. And that's the thing, chat. Sometimes they may agree. They may all agree. Let's say they all want to convict, and they're like, whoa, 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 whoa. We need to take 15. We're going to take, we'll take 10. And we'll come back. And then let's say it becomes an 11-1 guilty. 11 to convict, 1 to acquit. You notice, until you've marked out all the paperwork saying we've got a verdict and we're giving it up, they can't stop or turn around and say, okay, we'll put your hand down. We're taking your previous score. No, you're allowed to you're allowed to change your mind. And they say jurors should not be precluded from reconsidering previous votes. And the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. And they say requiring a well, I'm glad you guys are talking about exercise over there. And they say requiring a jury to publicly affirm their verdict in open court thus serves a vital purpose. It ensures that the verdict is truly a reflection on the unanimous and deliberate judgment of each juror under public scrutiny rather than a mere compromise. But you know what, chat? We know there's all kinds of compromise verdicts. We know there's compromise verdicts all the time. We know there's a compromise verdict all the time. We talked about them before, guys. I've mentioned them to you. We have them all the time. We have them all the time. We have them all the time. And they say maintaining this distinction is essential to preserving both the confidentiality of jury discussions and the integrity of the judicial system. Are they being good or bad? Oh, Clyde's doing good. He's being a good boy, guys. I was listening to 2.0. So they say, thus, because the jury did not publicly affirm the defendant was not guilty of the charges, there was no acquittal barring retrial under the Double Jeopardy clause. If you don't return a verdict right, it's not a verdict. You have to understand the assignment. And this is an interesting one, chat. So they said signed verdict slips reflecting votes of not guilty found in the deliberation room after a mistrial had been declared due to a deadlock did not constitute the acquittal. So that's an interesting one to look at. So there was a time where they had signed acquittals. They had signed not guilty. But for whatever reason, they decided not to send them out, and they kept deliberating, and they said, we're not going to make it work. So those are not valid anymore. Now, you'd like to think if that was the case and they filled them out, it didn't work, they'd rip them up and ask for new ones. But they didn't. So they just left them all sitting there. It's an interesting one. I've never heard of that kind of situation before, but it makes sense. So they say information indicating the jurors were deadlocked 11-1 for conviction, but only in the second degree. And they had purportedly agreed the defendant was not guilty of murder in the first degree, did not bar a retrial because there was no open and public verdict of not guilty. Oh, so it's all you have to do there. They say the request for post-trial juror inquiry. And they say, finally, we consider the denial of the defendant's request for the juror inquiry, basically the juror interviews. And they say, generally, a judge is not obligated to investigate jury deliberations unless there's evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. So, guys, remember, we normally say you can't talk about what the jurors said in discussions. Remember, if one of them's just sitting there screaming the N-word over and over and over again, it's screaming about total nib of death, yeah, there's going to be an issue of whether that guy was fair. And there certainly would be racial bias. And they say, even in cases of alleged bias, however, the inquiry cannot delve into jurors' subjective reasoning or deliberative content. Yes. Now, they could say, what did you guys talk about? No. But can they say, did that guy run around screaming like a loon? Sure. And we hear that happen from time to time. And they say because the trial judge afforded broad discretion in assessing whether the inquiry is appropriate, we review the determination only for an abuse of discretion. Remember, chat, the abuse of discretion is a very low burden compared to de novo review. Abuse of discretion just goes, did they mess up? No. Okay, cool. Remember, so it's government workers reviewing government workers. Like, you're not going to, you don't always generally find the problems. And they say here the defendant concludes the affidavits do not indicate. They concede the affidavits do not indicate exposure to extraneous information or juror bias that would suggest her right to an impartial jury was compromised. And they say instead the affidavit suggests an unannounced verdict warning further inquiry. And they say, yet as discussed already, the verdicts require public announcement in open court. Now, they said no verdict will exist if none was announced. Or even intended to be announced. And remember, this goes back up to this issue here of the jurors filling out slips. Right here, this one. They had slips filled out. They had their slips filled out, and it still didn't matter. It still didn't matter. So no verdict was exist if none is announced or even intended to be announced by the jury before they were discharged. So it doesn't matter. It doesn't matter. And they say once the jury's been discharged, they have no further power to deliberate or agree to a verdict. Very true. If they're done, they're done. And they say after inquiry, no private agreement reached in the secrecy of the deliberation room would also contravene our prohibition on the content of deliberation. Maintaining the secrecy of those deliberations is a bedrock of our judicial system. Yes. But yes, allowing inquiry into the private agreements would reach all kinds of problems later. And they say we don't pry into them because it not only prevents jury tampering, but also upholds the finality of juror verdicts and fosters confidence in the judicial process. Now, if every time you're on a jury, you end up getting questioned by everybody, you're not going to want to fucking do it anymore. You're not going to participate. You're going to be like, fuck that. So that's what happens here. And they say probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine the fundamental fairness principles. And honestly, chat, when you read this sentence right here, this is a sentence you guys have to listen to. You have to listen to this sentence. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned, and it says would. And then it says again, undermine these fairness principles. So when you put it like that, I guess I'll say like this. When you put it that way, it's really, really stark. Like the way they're making it makes it even easier for us to say, okay, wow, fuck that. And I think some of you guys would agree if you're being honest about it. It makes it even easier for them to look at this and say, yeah, that's what we're doing. So even this private verdict would cause all kinds of problems, chat. So that's why we can't do it. So, and they say, they keep going here and they keep going to further discuss things here. And they say, were it otherwise, jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts that might be used to set aside a final verdict. And that's true. Think about it. If you were allowed to harass them, the defense attorneys would be like, oh my God, tell me what happened. Bullshit, I know you did it. The prosecutor would be up their ass too. Like, it would never end. It would never fucking end. So no, it totally makes sense why, and like I said, the Massachusetts Supreme Court is making very compelling arguments here that are really hard to disagree with. So Jim Turner says there's a constitutional right to harass a jury. I don't know about that one. Maybe they're in the appendix of the Constitution. I would not recommend it. And they said, nor is the defendant merely seeking juror testimony as to a mistake entered on the final slip. They're not just saying, oh, it was a mistake there. And they're saying juror testimony about mistakes made in entering the verdict on the forms. Like, let's say there's something where everybody clearly knows that was wrong and we messed up. Okay, that would be able to be fixed. And they say here, there is no suggestion the jury's failure to return the verdict was anything other than the result of a clerical error. So they say the post-trial accounts do not dispute the jurors had reached an impasse, as they had not decided to return a verdict slip on any charge. They say, and as cases cited, permitting testimony to correct the clerical mistakes without outside influence immediately indicated error in unannounced verdicts. Yes, it would be. We don't want unannounced things. We want some basic structure and adherence so we can operate properly. It says, no juror expressed surprise or disagreement in court when the judge declared a mistrial, based on the jury's report that they cannot reach a unanimous verdict. Now, that's the thing. Like, if one of the jurors said, whoa, judge, wait, no, we actually don't disagree. We had actually all said not guilty. Like, nobody's trying to correct the record. Now, we have a statement from one of the Karen Reed jurors that was given to a reporter today, and we're going to go over that in a second. Show you the contrast with that. So they said the jury inquiry is permissible where jurors audibly answer no during polling of the jury. So, guys, when you have that conviction and you start, juror number 1, is this your verdict? Juror number 2, is this your verdict? Juror number 3, juror number 4, juror number 5. And if you get to juror number 5 and he goes, no, guess what we do? We would stop and we'd be like, what was that? And he'd be like, I said no. And then we'd have to figure out what happened. We'd have to figure out what happened and unfuck the issue. So you have to be thinking about it. You have to be careful. You have to think about it. You have to be careful. So they say, additionally, the limited exception for juror testimony concerning mistaken verdicts only results in an alteration of a verdict where there has been no opportunity for outside influence. They say here, all defendants' affidavits concern jurors' accounts to others after leaving the control of the court. And it says, when the jury leaves the sterility of the courtroom's control, contamination is presumed. So, they said the post-trial inquiry of these jurors would similarly occur well after they became susceptible to outside influences and would not provide a recognized basis for altering the result of the first trial. And they point out, they say, thus, the trial court did not err or abuse her discretion in denying the request for such an inquiry when it would not change the outcome of the defendant's first trial. They say, the jury chose to report a deadlock, not a verdict. And no basis exists for further investigation into private discussions or subjective beliefs they declined to announce publicly in open court. So they're telling you here, chat, you can't do anything about it. There's nothing here. There is no there. Even though you have these 5 jurors saying, yeah, this isn't what we were agreeing on, and gives you that, is there a there? You don't have it. That's not enough. And I don't think remember, that's not even half the jury. It's not over half of the jury. It's a minority of the jury saying this. So is it wrong for the court to ignore it? No. So, yes, there. And it says, for these reasons above, the trial judge correctly denied the motion to dismiss and request for a post-trial juror inquiry, saying we're not having that. The case is remanded to the county court for entry of judgment, denying the defendant's petition for relief. So, and that's so ordered, and that's the Supreme Court's case, and they don't have a dissenting opinion. So that's it, guys. Karen Reed's going back to trial on all 3 charges. Wow, we got that done in just shy of an hour and a half. Wow, I'm impressed. So Eric says, what if this trial ends at another hung jury? Technically, you can, if let's say hung jury, retrial, hung jury, retrial, hung jury, retrial, hung jury, retrial, hung jury. Theoretically, this could go on for a while. I've heard stories of people, convicted on their 6th, 7th trial. Because it's not a double jeopardy issue. So that is the ultimate issue here. It can keep going and going and going. Sky Queen saying same judge. Yes, it'd be Judge Canoni, unless you can find a reason for her to be removed from the bench. Are you going to accuse her of some sort of impropriety? Then you could probably get rid of her, but you're going to have to do that, and it's going to have to stick. Tenok saying same jury or new jury. You get a new jury every time. That is the one thing that will always change, because if you have a new trial, you need a new jury because number one, they've already heard it before. But it just doesn't go well that way. Does the state have to present the same case at new trial? No. They can do a different theory. Now, the problem is, and we're going to see this in Karen Reed's case, they've got better crash experts. Far better crash experts. Well, what's going to happen to them? Well, they're going to remember they had the trooper guy who basically sat there like, oh, I draw with a crayon. Well, that testimony is going to be available. Everything that was said previously at trial is fair game. So the state or the defense has the ability to get all kinds of stuff and ready to go. So it's something to think about there. It's something to think about. That's James says there was just a SCOTUS case recently about this. Yeah, McElrath versus Georgia. Kimbo says, I heard a Fed sent you something. Yes, I got a box, but I'm going to wait till tomorrow to open it. Judge D's nuts. Tim Beatty saying she would recuse probably just because. No, I don't see her recusing. I don't see her quitting till they force her out. So I don't see it happening. They're saying evidence tying Reed to the crime scene was razor thin at best. Yeah, but sometimes, chat, that's all it takes. You don't have to have a smoking gun. Yeah. Self-defeated says he graduated Sugma cum nuts. Fenris is saying, I say that more judges need to do directed verdicts or they can judge the backbone. So here's the thing when it comes to that. I feel like I'm dickers when I come in and do this. Here's the problem when you do a directed verdict, though. Judges don't want to do it because it's kind of like that Futurama episode where the thing that's pretending to be the thing that's God, the cloud, is like, sometimes the best way is when people don't even know you're there. And you don't even do anything. The judge would rather, let's say the judge thinks it's an acquittal. The judge would rather the jury come back with an acquittal. And then instead of having him to do it, because we want the jury to make the right decisions. We want a jury to take care of it instead of the judge. But if the judge truly thinks this person's not guilty and the jury fucks it up, the judge can step in and kind of shield you and go hey, bro, I got you. You're good, man. You're good. You're good. Not guilty. I know the jury just convicted you, but I'm not letting them do that. Get out of here. And you basically block the jury. We don't want that to happen if we don't have to. Because that undermines the ability of a jury, because the jury would just look at it and say, who gives a shit what we say? If we don't agree with the judge, it doesn't matter. And that's what they'd be worried about. Oh, we'll convict this guy and the judge will let him off. So that's the where did it go here? Yeah. That's the issue here. That's the issue. That's the problem. Like, that's why we'd like to think it, but remember, you bring up the other problem. Judges are pussies. So, like Kyle Rittenhouse, Judge Schroeder was a big bitch. He wouldn't do what he had to do. He sat there and screamed and yelled at the prosecutors, and then he didn't fucking do anything. So you can sit there and argue about, oh, God, you can see all my white whiskers. You can say you want all this, but you don't get it. Like, you don't want it because it's not exactly what you're looking for. It's just something to think about. Aaron saying, what if Trupa's, Powell, and Proctor be on a one-way ticket the night before the trial? I mean, who knows if they're going to be available? Who knows who's going to have to testify or not? But I'm sure the defense will call them. Is this another kangaroo court case? Nah, I don't think so. It's not really kangaroo court. The prosecution's being bullshit, but Judge Cannoni is like, she's mid. Like, I know people are like, oh my God, she's bad, but she's not the worst judge we've ever seen in these cases. Like, I would argue the judge in the Murdoch case, that judge was fucking awful. Mariko True says, interesting that with the Penelope McGee case not guilty in bench trial administered by Judge Cannoni. So we haven't watched that yet, and at some point we're going to watch that because it's coming up. Karen Reed's coming up, but also it's a short trial. It's a bench trial. But it's different when you're at a bench trial because the judge is taking care of business. It's a one-person jury. Am I throwing Romans? No, I'm not throwing Romans today. Oh. You guys are ridiculous. And it says, Rocco, it's good to see you, man. It's been a little while. Saying, maybe Bev is afraid of going away to the puppy farm. No. Judge Schroeder, yes. Oh, jeez. My mustache has a will of its own. Black Sharpie will fix those whiskers. I'm never gonna fix that. That's the thing. People, I think it's so funny when people see me for the first time. They're like, "Does he dye it? Why does it look that way?" Because that's how it looks. Do you think I sit there with like just for gray and go like, "Cheep, cheep, cheep"? I'm just gonna make little wingtips right here that just don't work. No, why would I do all that? That's a lot of fucking work. It's also the idea of like, do you think I sit there with like a shoe polish thing and just go like right there to just get the nice little ring? Like, no, it's just the way it goes. It's just the way it is. I mean, it's been that way, but soon this is probably all gonna, it's all hanging on. It's hanging on. Let me tell you, chat, it's hanging on, but it's not, it's hanging in there. It's hanging in there, chat, but I'm eventually going to lose the battle. Eventually, we're going to lose the battle. But also, it's not like I could do anything about it, because if I change the color of it right now, you could be like, oh my God, Sean, what happened to your hair? And I'll be like, oh, all the gray hair fell out. Like, no, nobody's going to believe that. No one's going to believe it. I said pussies, yes. The Grays are claiming Sean's face faster than chat. Yes. Yes. The judge in the Parkland shooting case was terrible too. Yeah, well, that was true, but yeah. Nate says, off topic. Did you already talk about the inferior courts trying to stop Trump's agenda? No. We found out from the First Circuit. The First Circuit said, no, we're not dealing with it. I am trying to get everything put together for tomorrow because there's a lot to break down and we have new things coming through. But there's also some things I have to sit down and put it together in a way that makes sense to you guys. Like the Paperwork Reduction Act is one of the things that the courts are asserting a way to assert jurisdiction and standing over the Trump administration. There's a lot of fucking weird shit going on, chat. So that's why we're going to work on putting some of that together. We're going to be doing that tomorrow night because there's no ASAP Rocky trial. So we're going to start probably right about 7:30 with all the Trump stuff, because at that point we'll have our hands full of rulings, and basically we'll be synopsising the cases and getting through all of it. So we'll do it tomorrow night, 7:30, Nate. But I do think it's always interesting, though. People are like, the coup, there's a coup. And it's like, filing bullshit lawsuits in the courts. You are the coup. You are the coup that you were talking about and fearing. So it creates a problem. The courts are being abused. The courts are being abused, chat. So, let's see here. I'm afraid to stand with Kanye. Yeah, a little bit. A little bit. All right. Green Top Machine Tool, how you doing, man? Saying the worst thing after my accident is that I put a lot more gray in my beard. Well, oh. Name of some sort says, I don't get why you don't shave those black parts off your beard. It's slightly distracting. I mean, because then you kind of like, no, I mean, like, that seems like that's a lot of work. Instead, you just, shave them up and trim it up so it's nice and clean, and keep this area clean, and you're good to go. That's what Cuck Murphy did. Fuck you, Ag. Suffa, how was the Super Bowl again for you, buddy? How was the Super Bowl again? Go for the Paulie Walnuts look, yeah. The Tony Sirico look. Angela says dye purple. That'd be funny one day. Maybe, chat, maybe. Maybe. What do you guys? Yeah. Destiny's a girl's name. Okay. Don't forget Richard Allen's judge. Well, yes. God, Judge Gull was a shitty judge. Yes. Are we going to cover Russell Greer? Yes. Yes, and we will at some point, chat. It's the undermining and destruction of the ability of the executive branch to do its job through lawfare, I think, is a far greater question that people are using lawsuits to assault and cripple our government. Is a bigger concern than Russell Greer. So we'll leave that alone. Yes, ASAP Trumpy. SB Seller saying Trump should just reclassify the Trump stuff, then the Paperwork Reduction Act won't apply. I don't know if it's that easy. There's some things I need to look into with that, but there are ways Trump can fuck back on this. But remember, they're separate but equal branches. So guess what? If they're all equal, they can all fight each other, and the government does ignore itself at times. So there you go. What's your funniest former screen name? I don't know. I've had a lot of funny ones. Sweet Bovine saying, and guys, we're kind of catching up on other things right now, saying, I've watched a lot of attorney Andrew Branca's videos on the matter. These activist judges should be barred in the judiciary. Oh, I think they should be impeached. And that is the neat part, chat. Remember, check and balance. So they want to act out. We could check them. Be like, listen, motherfucker, Congress is impeaching you now. Boop, off the bench. Or we could do the Joe Biden thing and pack the courts. That was all the rage. Not anymore now, but yes, we can pack the courts too. The YNW, YSL, ASAP Rocky, yeah, well. Aaron says, my dad bought Just for Men once in the 90s. It came out of the bathroom looking like Elvis. Funniest thing I've ever seen in my life. Well, yeah. Let's see here. People are looking at the beard and don't notice him reaching for the switchy. Angel says the salt and pepper looks good. Don't touch it. I'm never going to touch it. Number one, that requires work. Like, you would have to keep up on it. It's like, when women get their hair dyed. You have to keep up on it or the Roots show. That's too much fucking work. Because you have to keep up on it, and depending on how you have to change how you cut and wear your hair. Like, I'm not re-altering any of that. It works for me. It works for me. And it took a long time for it to look like this. I mean, I'm telling you guys, there was a long time there where I had a bunch of black hair and like little white hairs poking up, or I had like little kind of clumps and patches of gray hair poking through. And the gray hair seemed a little more wiry and coarse. And just the way it would lay, it seemed like they were like little boop, 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 boop all over the place. So I'm glad it's at this point. It took a long time, but I'm happy here. I am happy here. I like how Sean and Clyde's gray patterns match. Okay. Well, thank you. That's a shame since I literally never noticed the color of your facial hair. Fair enough. Fair enough. Shave it for the 25 again goal. No, but I thought at some point here coming up, I think it'd be funny if I just started a Thursday night show with like clean shaven and just ignored you guys for like the next, and just did the show in the next 3-4 weeks, and then until this grows back, and you'd be like, fuck are you guys talking about? There's nothing wrong with this beard. I thought it'd be so funny to try it one night. My body hair is racing stripes. Nico says, I love how Sean translated for me, and that's fair. I can't send this in the super chat, but needed to know the disinformation about the TRO. Well, which one? Because remember, there's a couple of TROs. There's a TRO out of Rhode Island. There's a TRO out of the Southern District of New York. There's a couple of them, chat. There's a couple of them. So, yeah. Let's see here. Impeach the Felchers. Yes. Yes, when you make peaceful revolution impossible, you make forceful and violent revolution inevitable. Yes. When you won't let us exercise power, we will use vulgar displays of power. So, Rocco says Obama was a real court packer. Yes. And chat, we're also going to talk about the whole Doge thing tomorrow. We're going to explain kind of how the Doge stuff worked. And if you really want to understand how the U.S. Digital Service, and it's now the U.S. Doge Service, is working, you could thank Obama. Obama created a digital kind of like organization to deal with the government because like Obamacare kept crashing. If you guys remember back in the day, the Obamacare website was a fucking disaster. So part of their job was to get government caught up. So Trump used it and repurposed it and let Elon and the boys run wild. That's why Congress can't stop funding. It's a separate agency. But we're going to talk about that tomorrow a little bit. It's a very funny story. It's a very funny story. So let's see here. Where is... Oh, Judge Gold's still on her bullshit, by the way. She's the chief judge. And just issued an order prohibiting all devices from the courthouse, including attorneys? How the fuck are you going to schedule anything? Like, if I'm an attorney, you know where my calendar is? This is my calendar. I don't carry a calendar like... I'm not some boomer. Like, I'm not some boomer sitting there flipping through my big calendar book. Like, I don't have one of those. I wouldn't want one of those because it's a pain in the ass to do 2 entries all the time. Like, who the fuck would have that? Fuck that shit. Fuck that shit, dude. I just use Google Calendar. And it's accessible. Like, God forbid I die or get in a car accident. 2.0 can look at it and help me figure out what's going on. Catherine says, how did the church end up owning the Proud Boys? I don't know. Huh? I don't... Hold on. Huh. The trademarks. Okay. Let's see here. This is interesting. Okay, so the church the church that the Metropolitan African Methodist Episcopal Church owns a Proud Boys trademark, so the far right group can no longer sell hats, jackets, or anything emblazoned with their name or logo without the church's permission. And the church can also seize profits for it. Okay, well, guys, if you guys remember during 2020 when Enrique and some of the guys jumped the fence and they burned the Black Lives Matter flag, they had to owe $2.8 million. So since they couldn't afford it, the court said, hey, we're going to take your trademark. Well, it doesn't matter. The Proud Boys sell all kinds of merch and shit on their own. Like they're not like it's an organized group like that where there's like single distribution points. Those guys sell merch back and forth all the time between each other. So you think that's gonna fucking stop the Proud Boys, I guess. But that's what you must be talking about. And you know what? We'll save that for Thursday night. Because all they are just proud Western chauvinists who refuse to apologize for creating the modern world. And they say, what we now see is a judicial insurrection. Yes, and I think that's a fair way to look at it. We are seeing a judicial insurrection. We are seeing a judicial coup. That's Shane says, I have to be blonde for the rest of my life. Well, yes. Am I going to call Turtle Boy? I don't even know what what do you guys, what is the deal with Kurt and Turtle Boy? I don't even know what the hell's going on. Colostomy Bag says the curtains match the drapes. Well, only your mom knows. But you're going to have to ask her. Yeah, there's a fuck ton of TROs right now out there against Trump. Jeremiah says, I would see my fat face and be AWOL for a month. I've done the same. Yeah. Let me see here. Kia Patrick says, while I wasn't involved, I worked for the company that was responsible for the Obamacare website. Well, thank you for that. I appreciate it. Stacy says our court doesn't allow cell phones or Apple Watches. It's stupid. Yeah. Is this an S24? No. There is no point like buying phones like that. What's an S24 cost right now? Amazon. Let's see here. Let's see what they are on Amazon because that might be cheaper right now. Galaxy S24. What's an S24 run? An S24 is $800 roughly. Why would I? Yeah. Instead, if you go to the Samsung, you get the A models. So, like for the longest time, I had an A42. It's a model that has a very high def screen. It's got a very bright screen. It's got a decent battery, and it's meant for people like you can use it for like social media purposes because it's got a really good camera on it. But more importantly, the A series of phones from Samsung are like half the price, even cheaper. And like I had an A42 probably for like 3.5 years. Why? Because I could repair it. And that's the neat thing about the Samsungs. Some of them you could repair, pop out the screens, replace and fix pieces as you go. Like I have a couple of cannibalized A42s I've used over the years. Because it was cheaper than putting like $1,000 down for a brand new Galaxy. Like, why would I do that? The S models. The A models are like, they're a bargain. They have a lot of memory. You can do all kinds of cool shit with them. But there's, buying an S model. Fuck that. Fuck that, guys. That is retarded. There's cheap, good phones out there. You don't need the best and the brightest. So, that's a shame saying you have to file a written motion in every case every time you appear in the courthouse. Wow. 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 I motion for the judge to fuck themselves is like the motion that needs to be filed. Whoa. That is horrible. That is fucking awful. That is awful. It's awful waffle, man. That is not good. Oh. So, you don't have an old-timey Rolodex? No. Um, that's shame says, I mean, they're really obnoxious when they keep interfering with the judges trying to do their job, throwing people in jail. Yeah. That would just be really fucking awful to keep up on. Okay, Aaron's saying Turtle Boy called Kurt out live on Sunday night stream and left them a message after Kurt called him out live on one of his streams for something he knew nothing about. Oh, okay. Oops, shit happens. Is it an S22 then? No. Eric says I had an A71. Yeah, this is an A54. Then 2.0 got this for me for Christmas. So you thought I was an iPhone guy. No wonder he promotes the green. I didn't like iPhones. iPhones were really, they just weren't my jam. I tried one. God, it's been over probably 15 years now since I tried an iPhone. No, hold on. No, it's been at least 10 years since I had an iPhone. I tried over 10 years now, actually. Yeah, probably 10, 12 years. I tried an iPhone, just didn't do it for me. I mean, it wasn't good. It wasn't good. So yes, we shop smart, not hard. Yes, shop smart, smart. Snoop says, "Holy shit, nobody cares." Yeah, well, some people did. The Google Pixel never tried it. Kara and them, Kara Wanky were working on how to challenge the things out there. Yeah, hopefully that works. I probably have a moleskin hidden in the lawyer's safe. Yeah. Let's see here. You guys are talking about iPhones. iPhones suck. iPhones suck. So, yes, apparently, here. I have an A23 that works great. Yeah, they're good. They're good models. I needs not to say Kara's surname. Why can't I say Kara Winicky? Or Winicky? It's Winicky. Why can't I say it, Hella? So, let's see here. You guys had a bunch of comments. We need to go back through these. Jordan says, could you file an amicus brief for us in the penalty phase of Recatus case on the community dangers of cuckoldry? No. Guy Remake says, Nick called me fat again. Well, that's great. Augusto Pinochet says, are these verified facts of lawful law? Yes, they are. Patty F says, yes, Karen Reed's attorneys were hoping for a mistrial after the first couple of jury notes when they realized they weren't getting a jury. Correct. Yes, you just take what you get at that point. You take what you get at that point. And Stephen Cooper, I think we already addressed this, but yeah, shout out to the IRS. Yes. Let me see here. Oh, so apparently Tech Guy says it's nice to know Aaron can legally make boxes again. Yeah, I heard, I guess he's a boxer now again. And then J-Rock, yes, from what I understand, Gino Biscani, the prosecutors out in Minnesota formally requested Gino to show up. through the uniform acts that are out there. And we'll talk about this coming up, probably on Thursday, chat. I'm not gonna lie though, guys. Like where I lived and where I've worked, if we had some complaints, we wouldn't even fucking bother. Like going all this effort to fucking subpoena people who are like don't want to be involved, and it's all a shit show. It's like wouldn't be doing this. We wouldn't be going all this fucking work. So I'm surprised they're doing it out there in Stearns County, Minnesota. But then J Rock says the DA must show the witnesses material or material necessary and whatever is required. Yes. I just don't see, like, if Gino doesn't show up, I don't see them putting a material witness warrant out for him. They might just be like, oh, well, fuck it. We tried. I mean, that's more the realistic thing I see there, but you never know. Be happy to be wrong. Iman Reza saying, Gino was short for Eugene. You never knew that. Yeah. Yep. J-Rock says, I already educated chat, Sean. Well, thank you. So, I'd rather the state charge Nick for computer crimes instead. Well, yeah. Rocco's Life says, I can 3D print a material man. That's great. That's great. Let's see. What are we at here, chat? Let me see here. Checking to see if there's anything else there. Let's see here. Okay. So there's nothing else, just making sure it's out there. Do I know anyone who specializes in trust? How difficult or unusual it would be to have a trust payout based on the number of offspring? You could totally do that. You can set up a trust pretty much to dispense money however you want to. The only things you can't do are enforcing racial discrimination or any other type of discrimination that's illegal, because courts can't be used to enforce it, because that becomes a violation of the 14th Amendment. So you can do it by, like, every time you pop out a kid, you get a bump in payment. Like there's all kinds of ways you can structure things. You can structure on people going to college, but yes, you can do it per kid. Here's how much you get, and it'd be totally legal. That's Shane saying Richard Allen got phenomenal appellate counsel. He has the guy who had argued for him at the at the Supreme Court, and another person, Stacey Uliano, who's a rock star, easily one of the best appellate attorneys in Indiana. And here's the thing, chat. I just don't know if that's. I hope it's enough, but I'm just not holding out hope. I just, I hope the Indiana courts will prove me wrong. They're not a bunch of assholes. Young is saying, will you talk about Trump's plans for Gaza tomorrow? Yeah, I mean, we can touch on that too. I'll make a note for that. I just think we should stay the hell away from Gaza. Let them settle their own problems. Shinobu Tezuka says you can absolutely discriminate by nationality. There might be some ways you can, but you have to be very careful. You have to be very careful about how you do it, because you have to be careful about, remember, there are protected issues about, origin. So you have to be careful. The Orban Gambit. Yeah, well, Orban's playing everybody pretty well. Oh, Skinny, you're going to need kidneys, man. That sucks. Hopefully in the meantime, they can help you find some. Hang in there. What are the price of catalytic converters currently in Ohio? I don't know. Don't come here and steal them. I haven't had a client. I haven't had a client get caught stealing catalytic converters in a while. When I was in Toledo at the Public Defender's Office, we had guys who would get caught stripping wire out of houses. They would just like get the wire and they'd wrap it around like a pipe, and they would just run along stripping out walls and stuff. So, but yeah. Repeal the Civil Rights Act. Okay, well, while intriguing, probably not going to happen. All right. Let's see here. Let's see. Snoop is saying, holy shit, platinum is through the roof. Yeah. Precious metals are taking off, dude. Platinum and palladium are going to the moon. So, yes. Garrett calls it urban copper mining. Yes. That's what I called it too. I called it, in court, I called it urban copper reclamation. And the judges chuckled. And, the first time I said it, it kind of helped the guy out, not getting completely burned. So, Maddie says, I had someone try to steal one from my roommate and we greeted him at 2 p.m. on a Sunday under the car bearing gifts. Yeah, that can be true. Amon Rosa says maybe Trump can put the dollar back on the gold standard. No, okay, there's better odds of Clarence Thomas getting cloned 9 times and then giving us machine guns on the Supreme Court than the gold standard happening. So, Angela says it's been snowing in D.C. since 1 p.m. I've heard about that. I've heard it's been snowing pretty hard. Young is saying, in addition, would you let me know how much an aluminum garden box is going to cost me in a month? An aluminum garden box? What? If this is a joke, I'm missing it. So, you want one of those galvanized boxes? Well, I mean, they're not normally, you don't really galvanize aluminum. Aluminum generally, tarnishes itself and it protects itself. But if you're looking for one of those galvanized boxes, yeah, they're kind of not cheap right now. Oh, one of the raised aluminum planters. Oh, I see what you're looking at here. Yeah, aluminum's not too bad on price, so. Let me see here. Gold is $2,900, yes. Haschick says you have to provide your ID to metal recycle in Arizona. That's racist. That is so wrong. I mean, what happened to the days of just not being allowed to turn in burnt copper? I mean, I remember that where if I had copper, I go to the scrapyard and they're like, oh, you can't do it because it's burned. Because you'd sit there and burn off all the insulation off of Christmas trees and Christmas tree lights and wiring and extension cords. So you have to sit there and you could give them an acid bath. You basically scrub it all up, let all the soot get eaten off. And that's the only way they take it. Clean copper only. But yeah, I got to show your ID and stuff. That is so bullshit. It's such bullshit. And I used to I remember in law school, we were boy, you drive by, somebody had a refrigerator out and you're like, And you stop and get out and look at it. Somebody had already cut the guts out and you're like, damn it, missed. So. Let's see here. Young's trying to prep. Yeah. Aluminium. No, it's aluminum. It's not aluminium. It's aluminum. Aluminum. Do. Let's see here. Oh, it's not a joke related to the tariffs. Okay. Well. It's $200 right now. Yeah. Well. Hella says, when are we streaming tomorrow? 7:30 p.m. We're going to start with all the Trump orders. So we got a whole night to get going. We got a whole night to get going on it, chat. Skinny says, where does the scrapyard care who they get their shit from? I don't know. People keep stealing carbon or optic fiber lines thinking they're copper. That's so funny. You need a license in California to recycle more than $100 worth of soda cans. Fuck all that. And says, I wanted to huff all that Freon. Oh, hell no. I remember one night I was going to law school, and I had my work clothes on, and I hacked out with a pair of tin snips part of the back of a refrigerator. And yeah, I just let you smack it, you pinch it, you let the Freon vent because they hadn't done it yet, the homeowners. And you just sit there and cut it out as you're going into town. And it was funny, because I'm pretty sure I drove by people who were going to night school who saw me cutting, because I was doing it in the middle of Toledo. I was cutting out the fucking back of a thing. It was totally worth it. Copper was really good, man. There was a while, I think like 2011 or so, 2012, like fucking copper got retarded expensive. Like even like shitty coppers. Like there was like, I'm just trying to think, like, hold on here. Because it was like, you know, like there was all kinds of shit that was you know, that there was all kinds, but it was like even like the garbage coppers, like you could get all kinds of stuff out of it. But yeah, that's awful. Yes, we're gonna be having a Trump stream tomorrow, chat. Let me see here. What else you guys got going on? Yeah, back when China was buying it all up. Yeah, it was really ridiculous. Look at my eyes when I think about copper. Motherfucker, if you're out there scrapping, if you've never done scrapping, finding copper is like the best thing in the world, dude. It's out there. You're like finding mana. You know, it's like if you're out there playing Warcraft, and I know you're a Warcraft guy. Imagine just finding pools of mana, and you're just like soaking it all up. Finding pieces of copper, you're just like, yeah. Oh yeah. Copper reached its highest price of $5.20 a pound. Really? Oh, this past year. Okay. $5 a pound. Dude, man, that's some things back in the day. You know, I'm ripping up old ductwork finding lead-coated copper. I've done that before too. Chat. You have no idea. Hashtag saying when I worked for the DOT, they pulled 10 miles of street lighting wire, tried to recycle it. Okay, well, that's being retarded. You can't do that. Zibielo is saying, are the scrap fiends in Cleveland as bad as down here in Akron? I don't know, because I don't really do the scrapping up here anymore. But like when I was in law school and I lived in Toledo, dude, I got my fucking scrap on. Let me tell you, man. I remember it was so funny. It was so funny back in the day because there was at one point I had to go to school, and you know, one future Mrs. Martin 1.0 at the time, as I think it was before we got married. Like the place we were at had a grill, and it was like there wasn't anywhere we could store it, and it died. And I'm like, here, watch this. And I just pushed it out on this out the end of the driveway. It's like, what do you mean? I'm like, give it 10 minutes. And I went and got dressed to go to class. And by the time I came back, it was gone. She's like, what the fuck? And I said, you know, the grill body is all aluminum, or people took it. So yeah. Did you live on the streets? No. But dude, back in like 2010, man, time was tough. I'm not gonna say like I was, you know, some street, you know, some hood nibba, but like, dude, like, you know, like back then, like copper got retarded expensive. You know, you can make money scrapping. Like, yeah, you save up a little pile of stuff and you take it to the scrapyard once in a while. I mean, why wouldn't you? Why wouldn't you if you're just running into stuff? Kimbo says, you know, there's wire stripping machines now. Yes, but 15 years ago, you just light it on fire to strip wire. Am I admitting the criminal activity? I have never broken the law scrapping. I'm letting my inner Florida man out. Well, yeah. Remember, Florida man was somebody who came from Ohio to Florida. I have some Ron Paul Revolution copper coins. I remember those. That's awesome if you have them. Am I from the hood? No, not at all. Not at all. So, I was not working as a lawyer at that point. I was in law school and I was working at night. So, no, it's just got to make money, chat. And when you're working at FedEx and, you know, you make like $500 a week, it's like, can you make like another $100 somehow? Hell yeah, then you're going to do it. I was not stealing copper. If it's sitting on the side of the road, it's free. It's scrap. You're not stealing at that point, chat. You guys are just being little bitches now. You take your scrap once a month. Well, see, I don't have that kind of scrap. I don't run into scrap like that anymore. So, oh, so, oh, yes, I worked at FedEx. Yes, I helped deliver the Purple Promise from like 2008, and for quite a while. God, it's been forever. But yes, I did. Do I have a cache of Silver Eagles? I don't discuss what I may have or don't have in that regard. Skinny says scrapping is way too much work. At times it can be. At times it can be. So. No, I never tied copper wiring on to a car hitch and ripped the barn roof off. No, I've never done that. Angela says humble beginnings. Well, see, no, I mean, it wasn't that humble. It was just, that was the job I had, and it was a job that allowed me to work at night. Had phenomenal health insurance. I will say it was amazing insurance. And as much as I like the job sucked at times, the people who ran it were pretty cool with me keeping a schedule through law school, and gave my wife and I at the time really good insurance. So yeah, it worked. It worked. I have a feeling my basement looks like a pawn shop. No, but my garage when I had my house years back looked like a pawn shop. Let me tell you. So yeah, send me all your scrap copper, please. I'll take it all. I'll take it all. Oh. So I see the Zaco on your shelf, but is that a frame arms girl next to it? No, that is a what are they called? Something armory. It's when I was a member of the InRange TV's Discord, and somebody sent it to me. It's like the something armory. So I forget what they're called. But no, you had to put it together. So when I pick up a see, copper pipe, I can use copper pipe while I'm forging and doing the blacksmith stuff. You can use the copper to do neat things with. So yeah, a copper pipe would actually be very useful. So all right, guys. So with that said, it's 11 o'clock, and we will get ready tomorrow for a fun day. Ready for a fun day. So, no one tells Sean Trump ordered the end of Penny production. I saw that. Yeah. Oh, hold on. The InRange TV Discord. It's been many a year since I've been there. I'm probably banned by now. But God, that thing is probably. Oh, geez, that's a ton of years old now. It's a ton of years old now. So, yes. Snoop says a lot of obsolete electronics have gold plating. Yes, I know. See, I didn't fuck with that shit, but I know a guy when I worked at FedEx. He would told me he did. Like, he'd take the circuit boards and he bought like things of muriatic acid and he'd dump them all in there and he'd dissolve all of it. And then he would do like electroplating onto a piece of steel. And he had done some other stuff where it sounded like he's probably going to get cancer from, but he basically would electroplate, like, so it'd be like gold, silver, palladium, copper, all on these strips, and it would come off as like a film. And he would take a bunch of those and he would do it and do it and do it for a long time and have these strips of like metal film, and he'd try to melt them down and make like, pucks for all of it. So yeah, fucking ridiculous shit. But I was like, the way he told me he did it, I'm like, dude, man, you're gonna get cancer. I'm like, I don't want to, like, I don't mind scrapping for like, money that was out there, but I'm like, I wouldn't do that. Is that guy dead now? I hope he's not. He was a pretty cool dude. He was pretty cool. He was pretty laid back. He was an awesome guy. did really good. Took care of his wife and his kids, or his baby mom and his kids. Dude was pretty fucking sweet. You know, he like him and I worked together, and he, you know, dude got shit done. It's all fuckery. Yes, it is. In range is pure commie AIDS now. Yes, it is. I'm an anti-commie chud. I wouldn't be welcome in range. Probably not anymore now. God, I remember at one point bringing up the whole thing about tactical girlfriend being part of Chaz and being part of the little armed commissar brigade. Oh shit. I was stepping on a landmine. If you know, you know. So I'm a cash money guy. Yeah. Cash is king. Smash JT and G-Day Cobra are live. All right. All right, chat. So that is it for us tonight. We will, like I said, we're going to get started on all the Trump stuff tomorrow. There's so much to cover. I need to get a bunch of it all organized up, and we're going to rock and roll. Let me see here. Who is... Let's see. We'll redirect to somebody. We're going to redirect to someone here, chat. Oh. So, do you have an opinion on... You're still going? Yeah, we're going to end right now, though. We're going to land the plane, chat. We're going to land the plane. Thank you guys for being here tonight. I know some of you weren't interested in the Karen Reed stuff, so my apologies, but I wanted to get into it. Because ultimately, my thing, I was interested. But we're going to get into it tomorrow, chat. And we're going to be on fire. We're going to get back to it. It's going to be great. And redirect to bed. Well, I'm not going to do that for you guys, but we are going to do, let's see here. What do we got? What do we got for a redirect? Let's see here. Let's see if D-Day will let me send over there, Jeremy. Let me see if we can do that. Yeah, you guys, we can do Cobra. And it's like, you know, I like Jeremy. I like Cobra Cast. Oh, I think he does great stuff. I think he's a pretty base guy. So I'm going to send you guys over there tonight. So I will see you guys tomorrow, chat. And remember, until next time, don't land like Vince Neil's plane. Yeah. Whoa. Getting off the tarmac right into a G200. That was rough. So, but with that said, chat, I'll see you guys tomorrow, 7:30. Remember, until next time, just because you did it doesn't mean you're guilty. Especially your Karen Reed. She was found, you know, hung jury. So, good night, chat. And here we go. Take care, you guys. And we'll see you tomorrow, 7:30. 7:30, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was. He even knows he's